Thank you all for coming. My name is Sam King. I'm the president of the Honolulu, or the Hawaii chapter of the Federalist Society, and we're going to be talking today about the Janus case, which our speakers will explain more about, but is fundamentally about mandatory agency fees for public sector unions. I want to say a special thanks before we start to Chad Kumagai, who's in the back. He's going to be taking photos. He's the vice president of the Federalist Society. He's got an awesome bow tie on. He helped start all this up, get you all the food. He brought the food here along with R.J. Brown, who I also want to give a special thanks to for helping us out. Thank you. I also want to thank the Grassroot Institute. They're going to be helping out with the live feed on Facebook. And I want to thank Joe Kent, who's running the camera, Sean Matsui, who will be keeping time for us, for the speakers, keep us on schedule, because I know Dr. Akina's we got to keep it moving, get out of here. And then Derek Draplin also, who's in the back running the sound to make sure we don't get a lot of feedback. So thank you guys all. We're also, Derek probably and me will be running around giving out the microphone. If you guys have questions, please speak into the mic so we can get it all on the video. So without further ado, I'll introduce our speakers. Tony Gill, here you go. We've got a lay for you, sir. Ceremonial style. Tony has represented the University of Hawaii Professional Assembly since 1982, continuously in all labor relations matter. This is the union that represents the University of Hawaii faculty on all campuses and islands in Bargaining Unit 7, as defined in HRS Chapter 89, just in case you want citations over there. This representation includes matters at the grievance level, in consultation with the UH administration, in collective bargaining, support of legislative action, at the Hawaii Labor Relations Board, in state courts, and in federal courts. From 1982 to 1992, Tony also represented the Hawaii State Teachers Association as an associate in a law firm, working with his father. Tony has worked for a variety of other Hawaii public sector unions, providing occasional advice on specialized matters, but not as a retained attorney. Tony was Oahu County Chair of the Democratic Party of Hawaii for 3 terms. Tony has also represented the Democratic Party of Hawaii in a variety of litigation and administrative matters, including the constitutional question came up on petition to the U.S. Supreme Court about whether or not there could be open primaries in Hawaii. But unfortunately, sir was denied on that one, as Tony pointed out. And Tony graduated from Roosevelt High School, 1968, UC Berkeley, 1974, and Yale Law School, 1978. And this brings us to our next speaker, Robert Alt. Thank you, sir, for coming down. Here we go. We have a lay for you two. Thank you. Now, you may not know this, but Robert Alt is a Swiss bobsledder who competed in the 1950s for the Winter Olympics and won 4 gold medals. That's not true, but if you Google Robert Alt, that's what you'll find out. So Robert Alt has been the president and chief executive officer of the Buckeye Institute since 2012, where he also serves on the board of trustees. Founded in 1989, the Buckeye Institute is an independent research and educational institution, commonly called a think tank, whose mission is to advance free market public policy in the United States. Robert founded the Buckeye Institute's Economic Research Center and Legal Center, from which the Buckeye team not only imagines public policy victories, but compels them with sound data, objective research, and strategic litigation. I like that blurb from the website. That was good. Thank you. Robert is a nationally recognized scholar with expertise in legal policy, including criminal justice, national security, and constitutional law. Prior to heading the Buckeye Institute, Robert was the director in the Center for Legal and Judicial Studies, serving under former U.S. Attorney General Edwin Messi III at the Heritage Foundation, where he regularly advised members of Congress and Supreme Court litigants on complex legal arguments and strategy. Robert has published more than 100 articles and blogs. He's provided commentary on CNN, Fox News, PBS, numerous radio programs. In 2004, Robert spent 5 months in Iraq as a war correspondent. Robert has earned his JD from the University of Chicago Law School, where he was a research assistant to Professor Richard Epstein. He also, following law school, clerked for Judge Alice Batchelder on the U.S. Supreme Court, on the U.S. Court of Appeals for the Sixth Circuit. And in the middle, we have Dr. Keli Akina. Here you go, sir. Another lay for your lay. As you may or may not know, Dr. Keli Akina is the president of the Grassroot Institute. In 2016, he was elected as a OHA trustee at large. He earned a doctorate in East-West philosophy and ethics in 2010 and a master's degree in philosophy in 2000, both from the University of Hawaii, and a bachelor's degree in history of religion and economics from Northwestern University in 1992. He's also a graduate of Kamehameha Schools. He will be our moderator for the day. And without further ado, Dr. Akina, please take it away.
Well, thank you very much. Let's have a big hand for Sam King. Thank you very much. I have to say Sam King is one of our up-and-coming bright attorneys here in the state of Hawaii, and he comes from a very regal pedigree. But thank you, Sam, for also coordinating the Federalist Society activities. Grassroot Institute is pleased to partner with the Federalist Society, and I want to thank all of you for coming today. The two gentlemen I have to my left and right are people whom I have admired for many, many years, and I'm glad to call friends. I've had the opportunity not only to discuss legal matters with them, but to sit down and wax philosophical. And if you all want to come to happy hour later on tonight at Murphy's, we could perhaps get very, very philosophical. But today's case shows that what happens on the mainland does affect Hawaii, in case we hadn't figured that out yet. And whatever happens in Janus and Afscme will have ramifications that go beyond the legal, but will also impact our culture and our political world here in Hawaii. The case Janus versus Afscme is fundamentally a case about employment, unions, and the First Amendment. Mark Janus is a child support specialist in the Illinois government. He's not actually a member of a union, but Illinois law allows the state employee union to deduct dues from his paycheck and use those for union purposes every month. Now, the money goes to support union activities, which includes lobbying and political advocacy. 22 states operate under a similar system, while 28 states do not allow this to happen. Janus argues that requiring government employees to pay dues to a union or find another, violates workers' First Amendment rights to free speech and freedom of association. Why? Is this good? Is this true? Those will be some of the questions that will be discussed today between these two gentlemen who are experts in their field. And without further ado, you've already heard from Sam as to who Tony is. Tony's going to answer a question at the front end for us. What exactly is the Janus case? Tony, could you kind of outline it for us? And I believe you also have some slides. Please give a big hand to Tony Gill.
All right, Professor Roth, I know you're going to grade me. In the interest of accurate oversimplification, I will now rush through what could take 40 hours, okay, in about a couple minutes. The First Amendment, you've heard of it. What it does is it restrains government. It prevents government from impeding political discussion, which is required for self-government. Distinguish, please, between government as the sovereign, that is, in its relationship to all of you as citizens, and government as an employer, because government as an employer faces all the same problems any other employer would. Generally, the government is tightly restrained, which leaves a large area of free speech for you as a citizen, but is less tightly restrained, which leaves them more able to control and restrain your speech as an employee. Cases, for those of you who study cases, typically you'd want to look at Garcetti and Pickering. Sites will be available afterwards. Moving on. What the government needs to do is it needs to do all the things an ordinary employer would need to do. It needs to control, direct, discipline, compensate, and deal with all the employment issues that arise. It also has particular privacy interests and secrecy interests that are difficult to manage unless you have pretty spot-on control. So government has two kinds of choices. I'm going to simplify the many to two. It can dictate terms and conditions of employment to the employees, or it can provide some other method of shared governance, if you will. The first tends to make employees grumpy, and the second tends to make employees a little happier, although employees are never not grumpy. So, collective bargaining is a solution which has been arrived at under the second rubric for governments who want to try to create happier employees. And what this consists of is a couple of key principles. First of all, you are authorized as employees to vote for an agent. It need not be an agent. It could be an attorney. It could be a can of soup, but an agent. Secondly, you empower the agent to contract with the government to create what is called a collective bargaining agreement. Third, you as the government define the scope of the bargaining, all the rules of fair play, and how disputes are going to be resolved. This includes everything from the dispute over how to get terms in the first place, which could include strike, and how to enforce the contract once it is obtained, which could be typically arbitration in the grievance process. Now, your cites here, Constitution of Hawaii, Article 13, Section 2, that is a 1968 enactment, and Hawaii Revised Statutes, Chapter 89, which implements the same, and that would be as amended, numerous amendments since 1970. Now notice, one of the things that this approach does is it offloads from the state to the employees a large proportion of human resources work. I put a little exclamation point on the chart because that's a smooth move. Now, in order to make this work, what the government does, and that's the source of the contest in Janus, is it taxes all the employees for the agent's work. Okay? That's 89.4 in our statutory system. So, a quick history. For 50 years, more or less, and you can dispute exactly when this thread arose, but generally speaking, 50 years, the Supreme Court majority, because it has been a source of dispute in some cases, has held that it's legitimate to tax all the employees for the agent's work. It's not legitimate to tax employees for unrelated political assertions that a union or agent may make. Now, again, that's a distinction between government as an employer and government as a sovereign. Secondly, the Supreme Court has believed that it's possible to fairly distinguish political from collective bargaining related topics. It may be hard, but it can be done. Thirdly, the government has, the Supreme Court has believed that there are fair methods of assessing objectors for only the costs of collective bargaining and not the costs of unrelated politicking. Now, the cites on this are numerous and legion. Again, I can provide them afterwards, but if you get into Janus' case, you'll find these cases discussed at great length by both sides. Generally speaking, the key one that comes up most often in conversation is ABOOD, A-B-O-O-D. You can see it on the chart there, but there's a long line of them over a number of years that implement this concept of taxation of an agency fee to cover the collective bargaining agent's costs. Now, what are the contentions in Janus? Janus plaintiff contends chiefly that, quote, it's all political, unquote. There's nothing that a union does which is not political, and accordingly, it's not appropriate for the government to shield itself behind the employee screen. All of the things that unions do are political, and therefore, it is incorrect to assess any employee a mandatory fee to support what is in essence a political activity. They also point out that stare decisis principles should not apply if ABOOD was wrongly decided in the first place. Now, the Afscme response to this is something like the following. You know what, this case shouldn't be here because of a procedural botch-up. We can go into that later. It's fascinating to lawyers. Secondly, there are no facts in the case from which you could conclude what a union does. There's no facts in the case because this was decided on a motion without a trial in which the plaintiffs essentially called down fire on their own position to assure that they were dismissed out so they could take it up immediately without having to go through the bother of trying the case. Interesting tactic. Afscme asserts that governments do have the authority to tax all employees for the pro rata costs of their collective bargaining activities, and moreover that it is possible to separate them. And finally, stare decisis has importance in this case, particularly because of the large reliance of many, many states, many millions of employees on the existing setup. So what are the issues that are going to get tossed around here? I do urge you, if you have the remotest interest in this topic, and I assume you do, other than just the sandwich, you should look up the Janus case and find the transcript and look at some of the amicus briefs, because they are profound, they are wide-ranging, and they raise innumerable issues. One of the things that matters that will probably not come up in Janus but is a surrounding issue is whether an employee who objects to being taxed should be able to opt in or opt out. We can go into this more later, but that's an important point of civil rights. The procedural path. How did the case get up there? This is going to be litigated again, and in fact is already before the same judge in the Central District of California that heard the Friedrichs case, the father of Janus, and the court says that if the union wants to put up a defense, they're not going to dismiss out. So it wouldn't go up on a short form procedure. The Breyer-Scalia compromise. We can talk about that a little bit if you're interested. This is an alternate test which Justice Scalia years ago proposed in the Leonard case, and Justice Breyer in the current argument has brought up again. It would try to change the rule by which you discriminate political from collective bargaining. And that is of interest to lawyers particularly. The exclusivity of the bargaining agent. Ordinarily, the government prefers that there be one bargaining agent. If you have 2, 3, 4, 5, 10, 20, 50 bargaining agents, you have no advantage to the system. One bargaining agent gets them to offload all their HR problems to the union simply and not deal with contests between competing schismatic factions. So they prefer exclusivity. The integrated bar. Integrated bar of interest to you. Hawaii has an integrated bar. There was some controversy over it for a number of years. The integrated bar cases are very close to agency fee cases, and the impact of Janus could slop over to that very easily. The university student organization fees are another related topic. Typically, you go to a university, you contribute a university fee for speech, all the campus organizations get a share of it, etc. That is a compelled subsidization of some speech activity, the same as the integrated bar, the same as the agency fee. Now, here are a few of my annoying thoughts. And these are the things that are policy spin-offs that are potentially possible from the Janus case, or they are problems in the trial of the case. First of all, and I speak not in an attempt to summarize the case, but from my own perspective. The problem from where I sit as union counsel locally is that about 15% of what a union does is collective bargaining. About 85% of it is not. It's contract enforcement, consultation, or hand-holding. And hand-holding, I'm going to jump down to what I call the poor Jim yellow frisbee hypothetical. Jim is actually an actual person. So he's a union agent, and he sits in an office, and somebody comes in and says, you know what, I want a yellow frisbee under the contract. And he, after a long explanation, there is no yellow frisbee under the contract, you can't get it. He convinces the person that there is no such thing, and after a great deal of hand-holding and weeping, that person says, thank you, I appreciate the counsel, matter is resolved, I don't get a yellow frisbee, thank you, bye. Okay, now under the proposed Janus decision the plaintiffs have brought, that would be political activity. It would either be political activity on its face, or it would be political activity because it is aggregated through hundreds of frisbee requesters. This is problematic to me, because I don't think that sensible people devoid of ideology would call that political activity. Nobody heard it. It was private. It was contract enforcement after the fact, and it had no impact on the public fisc or public policy. Nonetheless, although that is 25% of what UPA does, that would be rendered political under the proposed Janus ruling, and I think the justices will struggle with that. So let me hop quickly, in the interest of time, to one other point. I've listed here a long list of things that I personally think are implicated in a possible Janus decision. We don't know it. I think we know where it's going to come out, but we don't know the rationale. These are things that are potentially tied because they are somewhat like agency fee problems. Thing one, the employee's retirement service. Employees are taxed and money is moved to fund managers who move them to corporations, both layers of which engage in political speech without any control by the employee. If agency fees cannot be taxed, can this be done? Or is it a First Amendment violation that allows you to object and get out of the employee's retirement system? Same argument regarding health fund. The Hatch Act. If everything is political speech, how do we regulate our ethics provisions? How do we regulate confidentiality requirements? How do we regulate whistleblower activities? Those of you who are around town may remember recently we had an interesting First Amendment bit of speech advocating that there was a nuclear attack. If every grievance is constitutionalized, Lordy, I've left a lot of money on the table over the years. And most interestingly, at the bottom of the list, if all of those activities are intrinsically First Amendment protected, all of those things that a union does, then how is it fair to prevent the unionization of all employees of the government? And moreover, how is it fair to regulate or prevent the most expressive collective activity possible, i.e. the strike? Now, so I want to stop here. Mr. Ault has been very kind to come in from America to discuss this with us. And he had the benefit of actually being at the argument the other day, which I envy him for.
Thank you, Tony, very much. That was a very complete and informative introduction to the case. As mentioned by Tony, Robert Ault was actually at the oral arguments, and he is the author of one of the amicus briefs. Robert, would you chime in? I'll give you about 5 minutes to indicate if there's anything else you'd like to add to the introduction, and along with that, some of your perspectives on what you think the justices really are saying by their questioning at the oral arguments.
Sure. First of all, thank you to the Federalist Society for hosting me today, for Dr. Akina for moderating, and for Tony for participating. I think I think that was a useful summary. My one core distinction I might distinguish between your use of the term tax. I think there's a fundamental distinction, and that elides a difference between my requiring you to pay something to a third party, which is what's the case in this particular case, and my taxing you for the general fund for other purposes. For instance, I can't, to show you why that might be important in a particular case, under Supreme Court precedent, I can take money from the general fund and I can pay it to a church, for instance, to finish a parking lot used as a playground in a recent case. But if I forced you to pay money to that church directly, that would raise very serious constitutional questions. So, differences in how it is that government effectuates particular policies can be important. So in this particular case, I think what we're talking about is not a tax, but a required subsidization of a third party. And that's where I think if you take a look at the questions that were asked by the justices, they really went into the question of sort of how it is that this third party uses these funds. And Justice Kennedy, who is traditionally the key swing vote on the court, was particularly aggressive on this issue, noting at one point early in his questions, what we're talking about here is compelled subsidization of a private party that expresses political views constantly, end quote. And that really is sort of the key. The example of the yellow frisbee, in terms of dealing with something that might be an absurdity, is an interesting question, but it's useful to actually take a look at what we know about how it is that unions have engaged in collective bargaining, not in political speech, qua political speech, but what it is they're collectively bargaining for. Again, I turn to Justice Kennedy and his questions in the case. They advocate for greater size workforce, against privatization, against merit protection, for teacher tenure, for higher wages, for massive government, for increasing bonded indebtedness, for increasing taxes. All of these are fundamentally political questions, and you can understand why it is that an employee may not wish to subsidize that particular speech. Or I can provide examples from where I live in the Midwest. Back in the day, you would take a look at a quarter and you'd think that this was potentially used to make a phone call. That's, you know, sort of ancient history now, I suppose. But in Westerville, teachers know this particular device is something else. This is a device used to determine your fate under a collective bargaining agreement, which is to say, the teachers union in Westerville, Ohio is so opposed to merit being considered as a factor in teacher employment decisions, including layoff decisions, that if layoffs have to be done at some point, and if there is a tie in seniority, at that point it wouldn't matter if the tie were between the teacher of the year and a teacher who had been reprimanded and was a poor performing teacher. The decision would have to be made by a coin flip under the collective bargaining agreement. Most people would say that's fundamentally a political decision. Or let's take a look at a case that arose out of Michigan. How many of you know what this is? A breathalyzer. A lot of lawyers in the room. I'm guessing that teachers wouldn't necessarily tend to know this, but in Bay City schools in Michigan, perhaps they would, because the collective bargaining agreement in Bay City schools said that a teacher could not be fired for showing up to work drunk 4 times. It was only on the 5th time showing up to work drunk that the teacher could be fired. The teacher could likewise show up to work stoned twice and not be fired. It was only after the 3rd offense of showing up intoxicated with illegal drugs that they could be fired. The teacher could sell drugs to their students once and only be subjected to a 3-day suspension under the collective bargaining agreement. It was only after the 2nd time that the teacher showed up and sold drugs to a student in the classroom that they would be permitted to be fired. It's difficult to say that that wouldn't be a political speech. So these are the sorts of things that teachers like, for instance, Rebecca Friedrichs was very concerned about when she raised her case, and Mr. Janus is concerned about. And it's not just those sorts of collective bargaining speech. There are also areas where clearly what is being considered as chargeable expenses for the purposes of the collective bargaining agreements would be things that, you know, issues of public concern that clearly have nothing to do with collective bargaining. Just as an example, the unions generally require the individuals who are paying agency fees to help subsidize their conventions. Those conventions include platforms that passed resolutions including demanding gun control, statehood for the District of Columbia, marijuana legalization, comprehensive immigration reform, an end to the use of state laws that protect religious freedom, and a resolution to demand the U.S. adopt the metric system. The metric system. Stop the madness.
Robert, very quickly, in less than a minute, can you give your impression of what the justices think about the Janus case from the questioning of in the oral arguments?
Well, you know, fortunes have been lost many a time by trying to predict how the Supreme Court was going to rule based on oral arguments. And you know, in this particular case, most people were looking at the dog that didn't bark. Obviously, this case had been heard once before, essentially in Friedrichs. Justice Scalia was on the court at that point. He, of course, had issued a separate opinion in the Leonard case, so people were looking at him, and it seemed like he was very much in support of defending the First Amendment rights of the workers in that case. He subsequently passed away. So all eyes now on his replacement, Justice Gorsuch, who seemingly knowing this fact was completely silent during oral arguments. Kennedy and Roberts, who are probably the other justices that people might consider swings on this seem to be pretty strongly supportive of Mark Janus's position. So if, based upon that, one would tend to think that there was that Janus has a slight edge in the case if in fact one can infer anything from silence, but I wouldn't read anything beyond, a potential victory. There's many ways that a Janus victory could be sliced, from standard of review all the way up to a more robust victory.
Thank you, Robert. Tony, if the court rules in favor of the plaintiff and if it outlaws agency fees, what would be some of the ramifications, particularly in Hawaii? For example, how would public sector unions make up the difference in the funding? How would they adapt? What are your thoughts about that? About 5 minutes.
Okay, this is an interesting question because as the rhetoric from the left tends to lump all corporations into one box, rhetoric from the right tends to lump unions all in one box, and they are not. I think that the first thing you'd want to look at is what is the culture within the bargaining unit. There are certain state employees, particularly the blue-collar ones, who come from a strong culture of unionization. Their peers in the private sector are unionized. They understand what is at stake for them, because more than any other kind of employee, they are kind of a fungible entity. And I suspect that in those units there will be a fairly strong solidarity maintained, even if agency fees become purely voluntary. I suspect that social pressure and tradition would require those folks to continue to contribute at a relatively high level. On the other hand, you have the state employees ranging through the clerical and quasi-professional ranks, even in the professional ranks, probably the university professors at the professional extreme, and within the university, people of the most fabulous variation. So I think that the first question is, what is the culture of solidarity in the bargaining unit? The second question is, what has the union, and some unions represent more than one bargaining unit, what has the union done internally to secure itself against the loss of income? What is its downsizing program? Another major question that would vary the result of the impact is, what is the state of Hawaii's response? Now, I recall from reading the transcript, and not having had the benefit of being there, that Justice Alito and Bill Messenger, advocating for plaintiff, had a colloquy in which it was resolved, at least to their satisfaction, that there is no constitutional requirement that the union be obliged to represent all persons under the so-called duty of fair representation. If that's the case, there's not a constitutional requirement, then it's clearly a matter for state determination. So states may adjust the DFR, they may adjust unit boundaries, they may take other steps, foreseen or unforeseen, in response to Janus. And those, the three factors I've mentioned so far, have a great deal to do with what the outcome is. How that impacts politics reflects, again, another level of speculation. Unions in this town have an undeserved good rep for political effectiveness. Some punch above their weight, some don't show up to the ring. Some have many members and little effect, some have few members and great effect. Some mobilize political action through membership in the field. Some create political results through the expenditure of money. So if the money is missing, that tool is gone for those unions, but that doesn't do anything to unions that actually do have the capacity to mobilize members en masse. So you've got a very complex situation, and as a result, I don't think that anybody can completely foresee what will happen because there's too much at stake that's variable. Additionally, the plaintiffs and their general supporters have a lot more cases in the hopper. There are cases to deal with most of those things that could be variables. So we're going to be looking at a chaotic situation, which will result, I think, in probably 3 to 6 months of intense hand-wringing anguish and the filing of many suits, and then a 3 to 5 year, possibly 10-year period of having all of the post-seismic activities settled down.
Okay. Well, thank you, Tony. And I'm going to switch over to Robert here, who's observed the evolution of public sector unions across the nation in his own research. And could you let us know a bit about what you've seen in terms of the impact of right-to-work laws on public sector unions and what you anticipate the impact of a ruling in favor of Janus to be on the structure of public unions?
So our brief in the Janus case actually looked at some of these empirical questions. What could we potentially anticipate? What would happen if, in fact, Mr. Janus were to win? And so what we decided we'd do is take a look at recent right-to-work states and the impact it's had on union membership rates and spending, and also take a look at the broader swath of right-to-work versus non-right-to-work states and membership trends to see what we could glean, what impact, if any, removing compulsory agency fees, which is to say the requirement to pay agency fees as a condition of employment, what removing that has on membership rates. So we took a look at 3 states that have recently enacted right-to-work laws, Indiana, Michigan, and Oklahoma, and we found that the unionized population actually increased after the right-to-work laws became effective. Looking first at Indiana, they enacted right-to-work in 2012. In the first full year after the law, Indiana added 3,000 union members. Numbers continued to increase in 2015 and 2016. Michigan enacted right-to-work in 2013. They saw a decline in membership, but numbers for 2016 exceeded those for 2014, suggesting after an initial dip, there was actually a correction and an upward trend. We actually saw this in a number of states that actually enacted right-to-work laws. It was an interesting trend where you had an initial diminution followed by an upward adjustment. Looking at the larger national trend, from 2004 to 2013, union membership rates in right-to-work states increased by 0.5%. Not setting the world on fire, but nonetheless an increase in overall rates. By contrast, membership rates in non-right-to-work states decreased by 4.6%. All of a sudden, that 0.5% is looking pretty good, given that it's in the positive column over the same period of time. You take a look at this and ask the broader question, can unions operate in a world in which they cannot compel agency fees? So, number one, we clearly have examples from the right-to-work states. We also have an example from the federal government system, which does not actually require agency fee payments as a condition of employment. The takeaway seems to be a couple of things. Number one, the unions don't need the compulsory agency fees to survive or even thrive. In fact, they seem to actually be doing more positively in recent years in right-to-work states in terms of membership growth than in non-right-to-work states, which raised the further question of why. And the answer seems to be adaptation and competition, which is to say, in states where there is right to work, where there's not a requirement to pay agency fees, the unions have to compete for the business of the employees. They have to be able to show and provide value to them in order to actually get them to go ahead and pay those union dues or agency fees. And they seem to be successful in doing so, which is to say they shift, and we do see some shift. Among the things that we see is in right-to-work states, the amounts spent on what we would traditionally call overhead costs seem to go down. relative to overall spending. And that seems to be consistent with the general desire of union members. When you take a look at how it is they would like to see their union dues, what they would like to see their union dues spent on. Another area where you could potentially see a modification would be in political activity. In survey after survey, union members rank political spending as among the lowest priorities for them in terms of spending, but it ends up being a pretty significant line item for unions. And so it's predictable that you may see a modification or a readjustment with regard to how it is that how it is and how much unions spend for political purposes. But in any event, what seems clear is by adapting, they're able to better appeal to their potential constituents, to their potential members, and not just actually sustain membership, but in some cases grow.
Thank you, Robert. And I want to ask Tony to respond a bit to that, but first let me give a little bit of context. It sounds like Robert is pointing out that we are in an environment in which public sector unions are evolving, and that's apparent to everyone. But what you're suggesting, Robert, is that Janus is not about pro-union versus anti-union, but that union members have much to gain in a positive ruling for Janus. I'd like to see what your take on that is, Tony, as well as maybe some comments on the culture of the evolution of unions in today's political and economic environment.
I guess my answer or response is on two levels. First of all, in the discussion you just heard, or the presentation of what union members may or may not want, I'm in no position to argue particular findings from other states. It's not my expertise. I accept what's been said. But notice that we all understood very well that union members hope for greater expenditure on their collective bargaining functions as opposed to political functions. Notice that we here in the room understand this concept. We can easily interpret it roughly. The argument in Janus is that there's no distinction. But I think that that's one of the reasons my hair gets rubbed backwards by plaintiff's presentation in the Janus case. So the unions vary in this town considerably in the amount of political expenditure that they make. And I think that one of the key distinctions to draw here is that first of all, the union I represent most, UHPA, doesn't have a national organization. It kind of went sovereign some years ago. Not AFT, not NEA, not AAUP. We just fly where we like. And as a result, nobody is remitting per capita to DC. Now, a lot of the people in DC sit there and they see the international unions, national level organizations are frequently called international, spending money politically, because that's what they do. That is their job to go to DC and bash on all the other folks who are bashing on the other folks in DC, and what makes that such a charming town. Out here in the Pacific, we spend a little bit from time to time, but nowhere near the amount or proportion that an international or national level organization would. So from the point of view of professors here, not even members are asked to support or made to support political expenditures. Members don't have to. So, and in Hawaii, the kinds of bargaining that led to the extreme and admittedly either humorous or absurd examples given before, I mean, people recoil with horror at that kind of thing. They also recoil in horror from the idea that a union could put a municipality into bankruptcy. In Hawaii, our scope of collective bargaining is so narrow, we can't bargain pension funds. We can't bargain much at all about health funds. We can't bargain most of the things that cause the governments to teeter. Most of the units can't even strike. So the political expenditures that are made in this context by the local unions are actually fairly modest. And frankly, are in danger of being overwhelmed by out-of-state expenditures that are possible under Citizens United. This is why I said before that the vaunted union effectiveness in politics is actually either legendary and mythical or not grounded in current reality. It's an unfortunate fact from the union point of view. The net amount of expenditure is likely to raise less ire than it might in other contexts. So I don't want to claim that Hawaii is completely unique, but we do have unique features of our law here. So I will gladly yield the rest of my time back.
Thank you, Tony. Appreciate that. Before we go to Q&A, I want to give Robert the opportunity to answer the final question, and it has to do in part with the response to Tony's analysis and the Hawaii scene. I know that although you're based in Ohio, you've been observing what takes place nationally and in particularly here in Hawaii. You were recently on Hawaii Public Radio with your views, and you understand a little bit about the union culture here in our state as well. So what lessons can we learn from other right-to-work states that can help us understand what needs to be navigated and what may happen as a result of the Janus case here in Hawaii?
Sure, thank you for that. No, I think like any other major question of this sort, culture matters. And so if you take a look, I think, at unionization rates with regard to right-to-work states, in those states or in those professions where there's a strong union culture, you see a much lower impact of in terms of opting out by individuals. And we should keep in mind, if Mark Janus, one of the things I think that Tony alluded to but may not have been perfectly clear, most likely if Mark Janus were to win, there's a few potential options. One would be that the court simply establishes what the standard of review is, which is to say, gee, we think that previous cases got it wrong and that heightened scrutiny is required for these First Amendment rights, and we send it down for a lower court to determine it, and then it has to percolate back up again, so we end up with what's really probably a fourth case trying to answer this question. They could, alternatively, if Mr. Janus were to win, say that he had this First Amendment right, but what does that mean? Well, it means most likely that to exercise that right, public sector workers would have to make the choice as to whether to opt out of the union or not. The default would be that they're in the union unless they took the steps requisite to opting out. And so one of the questions that we'd have is, who's going to be inclined to opt out? And I think the answer is, if you're in an effective union, if you're in a culture that has a very strong, if there's a very strong union culture in your state, as I think there is in Hawaii, my guess is that the number of individuals who would choose to opt out would be fewer than perhaps in some other areas. If you've got a crazy collective bargaining agreement like the one I just mentioned from Michigan, that, if your union is being less responsive, those are the sorts of things that might in fact encourage you to opt out of the union. So again, under the competition theory that we talked about, it probably does, make sure or shift union priority alignment more toward that of the individual membership in order to try and make sure that you keep them as members. But my general intuition is that the effect in Hawaii because of that may not be as drastic in terms of the number of individuals who would choose to opt out as in some other states. But it could, nonetheless, as we talked about under the competition theory, impact the behavior, how it is that the unions choose to represent what issues they tend to emphasize with regard to collective bargaining. The one distinction with regard to Tony's previous statement between the sort of political versus collective bargaining, the political speech, the political spending that they tend to disapprove of, that tends to be direct PAC spending. These are actual contributions from unions to political candidates, which are significant. I think over the past decade or so, if you take a look at the top unions, you're talking about over $600 million have been spent in direct political contributions. Those obviously are very significant, and those, again, tend to be less popular among rank-and-file members. As opposed to collective bargaining speech that may touch on issues of public concern. That's really the core of what we're talking about in the Janus case, not political contributions. That's already been settled by prior case law in terms of that has to be separated, and you already have a right not to contribute to that as a non-member. So.
Thank you. Thank you, Robert. And at this time, we would love to have your questions. And to do that, I'm going to call Sam King to come up and take the microphone here. And, in fact, invite you to pose the first question. And what I'd like to do is ask, while Sam is asking his question, anyone else who'd like to ask a question, just come to this aisle, walk up this aisle, and Sam will give you the microphone. So be the role model now, Sam, and you should show us.
Well, my first question was pretty simple, actually, since I'm being thrown right here for my genius question. Your data on right-to-work states, did that relate directly to public sector unions or to all unions in those states? Because I know there's a difference between right-to-work in the private sector and then agency fee in the public sector.
Yeah, no, I believe I'd have to take a look back at the data from the brief we got. It was from the Bureau of Labor Statistics, and I believe that it didn't disaggregate out, so I think that was both public and private sector unions.
Before we get started on Q&A, too, I want to make a few announcements. Please drop off your evaluations with Chad when you leave, and also pick up your certificate of attendance if you need the 1.5 CLE credit hours that we're offering to everybody. Also, I just want to let you know the Federalist Society is planning some future events. We're going to talk about affordable housing coming up soon, hopefully, and licensing laws in Hawaii. So that should be exciting. If you have any other suggestions, feel free to email me. Let me know. Anybody? So who's first
Very good.
on the questions? Oh, my dad. Okay.
No, I'm just wondering, does this case only apply to public sector unions, or is it possible that is this coercion by the state in the sense because it involves public sector unions, or are there ramifications for private sector unions as well?
I think most people understand this as a First Amendment case and therefore applicable to direct government action and most clearly to the government's relationship with its own workforce. It has political slop over, obviously, to the larger right-to-work question, but I think the answer is public sector only for all practical purposes.
Real quick, so not a fan of the integrated bar, as I'm not.
Yes.
I mean, you talked about we had that issue with the integrated bar, and then it voted down, and then they fed everybody a bunch of beer, and then it got voted in. A week later or something. So would this case, if Janus won, would this case apply to like a bar association? Is that considered state action?
It is a cousin of the doctrine, and depending on what they write, it may well. Now, Mr. Alt was correct to point out that one of the things the court could do is simply try to refine the standard of review. And as you know, appellate lawyers ponder standards of review the same way many people collect fine wine. And they wonder about the nuances and distinctions of these various standards. And depending on what standard is ultimately selected as the vintage du jour, we could determine that an integrated bar may be on weak ground.
Robert, any thoughts on that?
So as to the first question, it was interesting that very question was raised a couple of times in oral arguments, and specifically the issue of whether Shelley versus Kramer, would create, using that sort of a system. You remember that the question of whether or not the government could enforce a contract, which would be contrary to law, whether or not that would create conditions for private sector employers. I believe the Solicitor General was specifically asked that question, and he argued strongly against that. So at least in terms of the four corners of this particular case, even sort of under what I think is probably the furthest extension of sort of a state action doctrine that's been recognized, that the advocates in the case didn't think that this would be applicable directly, at least to that. With regard to the integrated bar cases, there certainly could be some application, and to a certain extent there probably should be some application to the extent an integrated bar would actually engage in coerced political speech. Most of the time when we think about sort of coerced political speech by bars, it's not by per se integrated bars, it's by external bar groups. The American Bar Association, for instance, is not it's not a state bar. It engages in a great deal of political speech with which I and many others disagree, and I'm therefore glad that I'm not compelled to give them money.
Thank you. Next question, or a quick comment if you want to make one. Anyone?
We're not leaving until you ask.
You need the full 1.5 hours.
Okay, we got a couple going on back here.
All right, Sam's catching someone in the back. Go ahead.
Hi, quick question. Does this possibly, Janus, create an incentive for public employees unions to support privatization under the condition that they continue to represent the workers, as in the Maui hospital case?
Tony, do you want to take a stab at that first, and then Robert?
Okay, this is a tricky one. The question is, would public sector unions, and he's thinking particularly of HGEA, support privatization, which would mean spinning off some government function to a private management? And in the imagined hypothetical, he's talking about spinning off from the State Health Systems Corporation to management by Kaiser, on the condition that they still remain the collective bargaining agent and thereby cleverly escape the problems created by a right-to-work regime on public employment, whereas they can get out of those strictures in Hawaii's private sector environment. Very clever question. The problem I have with it is I don't agree that the transition is seamless. I think that at some point in the transition, okay, deep breath, everybody. There's no successors and assigns clause in the existing arrangement between Hawaii Healthcare Corporation and the HGEA. Consequently, for those of you who are interested in making trouble for the HGEA, you should be out there pointing out that there has been none, and it's a very unclear question under National Labor Relations Board doctrine and Hawaii Labor Relations Board doctrine about whether you can simply transfer employees that way without an election. So, cool plan if it could work, but nobody's litigated the hell out of it yet. So I defer to the future.
Robert, I don't know if you've had an opportunity to observe our foray into transitions from government employment into what Tony called privatization, or what politically correct might be called public-private partnership, with reference to our Maui hospitals. But would you have anything to comment on?
Well, speaking from ignorance as to the particulars, but I think having the gist of what's potentially at stake, I could see where I think Tony's statement, obviously, with regard to the transaction costs and so forth, I mean, there's not obviously there'd be some risk. And so in some of these cases, obviously, there may be a determination made that unless we know that we're going to be able to succeed and be the successor union for a private entity, that risk might be sufficient to prevent them from seeking that jump. But I could see, going to sort of the larger question, I could see this promoting a shift to more private-public partnerships, or to privatization, to having private entities perform, if in fact, to a certain extent, unions were privileged with regard to being able to have agency fee requirements in the private sector that they couldn't have in the public sector. I could see that, once again, just legitimate business decisions by the union suggesting that that would be a better avenue for them if they felt that they would end up benefiting in that way.
I'm going to generalize a bit and take off of that question. The case of Janus versus Afscme deals with a public sector union. Our transition in the state hospital system on Maui involved employees going into potentially a private sector union. Are there any dimensions of that that might impact your response, Tony?
Yeah, I was trying to allude to that, probably too elliptically. To further complicate the question, short answer, yes, of course there are concerns in the transition between public to private sector, which are all untested, I think. But of greater interest is the fact that the union in question has both public and private sector components in it. So, and this is significant to the union geeks among us because the private sector components are subject to the LMRDA and the public sector components are not. What's he talking about? It matters. So, but Afscme has two heads, so they can pull this off successfully. Yeah, I think that there's an interesting question underneath it, but there's a lot that has to be excavated before you get to the question.
Thanks. And Robert, just to follow up, does this go back to something you were talking about a little bit earlier, that the hard and fast line in the sand between public and private may not be so hard and fast?
I think so. Although I do think that there are some core distinctions, and you can begin to see why it is that some of the First Amendment and other concerns are more robust in the public sector. Once again, when you're dealing with questions where it is the public fisc at stake as opposed to a privately run hospital, those really are ultimately more appropriately political questions. And so, you know, looking at this and saying, well, why is it that we should treat one under the First Amendment one way and the other something differently? You can understand, once again, in those situations that, now Tony had suggested that issues that might push a municipality into bankruptcy, those are beyond the purview of negotiations in Hawaii, but in many states they're not. In many states, those are expressly what collective bargaining covers, are issues like pensions. That very much was an issue with Mr. Janus in Illinois, where the pension system is pushing insolvency, and he's very worried about whether or not the pension system he's been contributing to will be there, given the stances that have been taken by Afscme in Illinois. Whereas, again, it's not necessarily a pure political question when you're dealing with private entities. So while there is some blurring, I think for First Amendment purposes, there's important distinctions that go to why it is that we may actually treat them somewhat differently.
We'll come up for air now and to open up for any other questions. Way in the back over here, sir.
I think we have one over
okay,
here.
Go ahead.
Yeah, we have one right here first. Okay. There you go.
Hi. As a mere faculty member in political science and nursing, it's delightful to hear the lawyers arguing the nuances. I do have two questions for you, Robert. The first is a very practical one. When you mentioned the three states, Indiana, Michigan, and Oklahoma, you didn't mention what had happened in Oklahoma, unless I fell asleep.
And that was merely the fact that I didn't jot it down out of my brief. But if you'd like, again, the overall results were positive, and I believe they're quoted in my brief, which you can find online.
Okay, great, thanks. The second thing, in the same area, when you were talking, you mentioned at the same time that spendings on political purposes had been dropping in those states, and I wondered how you were defining political purposes.
This went specifically to PAC spending. And in particular, I hypothesized they might, but the interesting thing actually is that the one state where I know off the top of my head what happened was Indiana. And in Indiana, actually, political spending did end up increasing, at least in the initial year after Right to Work was enacted. It stayed steady, I think, in one year, and then it actually went up, marginally in another year. And so in terms of that, once again, the statement that political spending might end up decreasing was a hypothesis based upon, sort of union worker satisfaction questions. The actual data from Indiana showed a modest increase or stability with regard to political spending, defined again specifically as PAC spending there. So on that count, we'll wait and see. As far as the overall political influence, though, it's interesting that that was probably one of the more heated exchanges in the Supreme Court. Justice Kennedy asked the attorney for the unions whether or not, if they lost this decision, they would lose political clout. And the union lawyer said yes. And Justice Kennedy's response was, well, isn't that the end of the case then? His point being that fundamentally what you're saying then is if in fact you're not able to compel agency fees, that you're going to lose political clout. Fundamentally, you're using those agency fees for political clout.
Tony, would you like to respond?
This is where I envy Mr. Alt for being present, because he correctly quoted that exchange. But notice there are two ways that a union can lose political clout. Way number one is as suggested, and as is Justice Kennedy's model. Sure, if for some reason union income goes down, and therefore political spending goes down, and therefore political clout is lost, doesn't that prove that union spending is all political? Not necessarily, because the other way is the good faith result of unions having to cover, through fewer and fewer contributions, the same number of people who are the same expensive drag on contract enforcement. So, for example, if you get a cascade of free riders, because human beings, being economically wise as they are, they reason, if I can get something for nothing, why wouldn't I? So the problem that the unions perceive in the loss of agency fee is that the next guy in line says, wait a minute, I get the contract, I get the wage, I get the grievance procedure, and the court says I don't have to pay. What am I missing? There's a 1% to 2% kajing for me if I just say no. That's a free rider thing. It's human nature, it's not ideological. It's the same thing as in ecology, there's the tragedy of the commons. People don't, it's the same thing when you log onto that website that asks you, gosh, haven't you been here a lot? Why don't you contribute? And you go, nah. It's exactly the same thing. People just don't. And so if there were, and this is the question, that's the political science question that confronts us, if there were a cascade of free ridership, the union wouldn't have money to spend on bloody anything, which does not prove that they're anything except that they're broke. It doesn't prove that they were making too many political contributions before. Now, one other point related to that, which I think everybody ought to appreciate in this town, direct political contributions to candidates over the past generation have been so highly regulated and dialed down that they're essentially meaningless. The law has removed political parties' ability to channel money. It's constrained the amount of money people can directly give to candidates that they support, but the so-called independent expenditures are a free fire zone. So basically, political contributions to candidates are old tat. We don't do that. The so-called independent uncoordinated expenditures are where it's at, and that's where billionaires get to play, large corporations get to play, and unions try to climb into the same scene. So keep your eye on that ball.
Robert, before you respond, we have a saying here in Hawaii, I'll explain to you later on, that we all can join in. It's called give a union a shaka.
Well, now I feel like we're off to the races. So there were several things there that I think are worth responding to. The first is the use of the term free riders. Again, the idea here is if in fact an individual is not forced to pay an agency fee, that they're getting some unjust enrichment. They're getting some unjust benefit by virtue of the fact that they're getting the same union contract that the other employees are paying for. But Justice Kennedy, again, in the Friedrichs case, in oral arguments, rejected that formulation and referenced them more as compelled riders, which I think actually is probably more the case, and that's really what we're talking about here. That's the core of the question. It's one thing if I'm giving you a benefit, if in fact the contract I'm giving you is the sort of thing that you would actually want, that speech you would want to engage in. But what if in fact instead of hopping in your Uber and them taking you to the destination you wanted to go, that they took you someplace you don't want to go, and then they charged you for the privilege of going there. You wouldn't be very happy with that, and you'd be even less happy if you had a First Amendment right at stake. And that's what we're talking about in these cases. Mr. Janus and Ms. Friedrichs, in both cases, were forced to engage in speech that they disagreed with. That wasn't a benefit to them, that was a constitutional burden to them. And let's not pretend that it wasn't. The question is only whether or not we're going to justify that infringement based upon some other larger interest. With regard to sort of the question of whether or not the union should be forced to do that, I actually do agree with Tony on a point that the question of whether or not exclusive representation, whether or not there's any constitutional requirement, I don't see any constitutional requirement to do so, and in fact I think that could be a remedy if the unions really are concerned about the effect of having to represent individuals who aren't paying agency fees. And then finally, the question of whether or not the unions would have money to engage in the representation. I think we've already established that in state after state where there are right-to-work laws in place, that the unions not only have been able to survive but to thrive. So that we found that even if you do give individuals the right to opt out, that unions are able to perform.
Thank you. And that was our alarm clock. With that, I'm going to go back to Robert and give you a minute to say aloha to everyone and any last thought that you have. And then Tony, take a minute to give any last thought that you have after that. After the word, these gentlemen will be available for you to interact with. Robert?
So with 1 minute, I'd say, I think that the big takeaway from the Janus case is that you can have your cake and eat it too. You can actually have First Amendment rights and have unions that are able to continue to operate and to thrive and to exercise the influence that they're seeking. We've seen it once again in the data. Looking at non-right-to-work states versus right-to-work states, the unions are able to continue to appeal to members. They do so by becoming more competitive, by becoming more adaptive, by evolving and reaching out to their members. But at the same point, you're able to respect the important First Amendment rights of the individual workers and make sure that they're not compelled to engage in speech that they disagree with, something that most Americans would consider immoral.
Thank you. Please give a hand to Robert Alt. Tony, final thought. Speak closely to it.
Does that mean I'm at an end? These are my final thoughts, people. The rhetoric about compelled rider and free rider is interesting because it is a proxy for a chicken and egg problem, or kind of a presuming the consequent. What matters is whether the speech that is compelled in the government's regulation of its employees as such is different than the speech of employees when they walk outside and put on their citizen's hat. That's what matters. If the government can't compel certain kinds of behavior within its workplace, that has spin-off effects that could be colossal. And if we remove from the union context and apply the same reasoning to the employees' retirement service, you can understand why a person may think, I have no need to contribute to the employees' retirement service. I have TIAA-CREF. I just as soon run my 401k. I have private investments. I'm a Bitcoin guru. Whatever. But that's very similar to the question that's being asked here. Now, what happens when you have a system which does not have the ability to charge, and I appreciate your point about the word tax, it was technically incorrect, to charge people in a system that requires participation. If the government can't do that, there are going to be problems with the government, never mind the unions. So I think that we agree on this, that there's a wide range of decisions that could come out from the Supreme Court. But for my money, the most important thing will be exactly how they write the decision that gets them to where they want to go, and we know they want to go, which is to defund unions. Do they write it in a way that also makes government unmanageable, or are they able to perform some kind of distinction, which I'm not seeing yet, that would contain the damage to the immediate target? That's what we'll be watching for, and I very much appreciate your attention. I appreciate Mr. Alt coming out here to discuss this, and thank you very much to Keli for moderating.
Thank you. Please give a hand to Tony Gill. Thank you very much. Well, thank you to all of you for joining us today. This has been an enlightening conversation and a civil discourse, which is something that is wonderful to have take place in Honolulu. Thanks to the Federalist Society and the Grassroot Institute for putting this on. And in closing now, back to our host today, Sam King.
Thank you.
Aloha, everyone.